Hi, my name is Eva Schewior. I'm the president of the German Patent and Trademark Office, and you're listening to IP Fridays.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzan and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
My co-host Ken Suzan and I are welcoming you to episode 171 of our podcast IP Fridays. Today's interview guest is the president of the German Patent and Trademark Office, Eva Schewior. But before we jump into this very interesting interview, I have news for you. The US Supreme Court has taken up an important patent law case concerning so-called skinny labels for generic drugs. Specifically, the highest US court is reviewing a case in which Amarin accuses a generic drug manufacturer, Hikma, of inciting doctors to use the cholesterol drug Vascepa in violation of patents by providing a limited package insert. In two landmark decisions, the UPC Court of Appeal clarified the criteria for inventive step and essentially confirmed the EPO's typical problem-solution approach in the cases Amgen versus Sanofi and Meril versus Edwards. However, experts are not entirely sure whether the Court of Appeal's decisions, particularly those relating to the determination of the closest prior art, deviate from EPO practice. As a result of Brexit, mutual recognition of trademark use between the EU and the UK has ceased to apply since January 1st, 2026. Use of a trademark only in the UK will now no longer count as a use of an EU trademark for the purpose of maintaining rights, and conversely, EU use will no longer count for British trademarks. Bayer is attacking several mRNA vaccine manufacturers in the US, for example Pfizer, BioNTech, Moderna. The core allegation: patent infringements relating to old Monsanto patents on mRNA stabilization. Bayer is seeking damages, not a sales ban. Disco Pharmaceuticals from my hometown Cologne signs an exclusive license agreement with Amgen, potentially up to $618 million plus royalties, for novel cancer therapies targeting surface structures. Relevant from an IP perspective, the license scope, milestones, and data know-how allocation. And now let's jump into the interview with Eva Schewior.
Today's interview guest is Eva Schewior. If you don't know Eva Schewior, she is president of the German Patent and Trademark Office. Thank you very much for being here.
I'm very happy that you're having me today. Thank you, Mr. Claessen.
So I have a lot of questions for you. A lot of users and myself also are very curious. So let's start right in. Shortening the length of procedures has been a stated goal since you took office. What is the current situation and which measures are in place to achieve this goal?
So, first of all, I'm very glad that German IP rights are in high demand. Even though applicants in Europe have multiple options today to obtain protection for their innovations, we have seen increasing application numbers for years at my office, even after the introduction of the unitary patent system. I see this as a very positive feedback for our work. It is clear, however, that the high number of applications lead to a constantly increasing workload. At the same time, we want to remain attractive for our applicants. This means we must offer not only high-quality IP rights, but also reasonable duration of proceedings. Ensuring this remains a central and permanent objective of our strategy. The average duration of proceedings from filing to granting is currently about 3 years and 2 months, provided that applicants file an examination request within the first 4 months after application, and provided they do not request extensions of time limits. In other cases, the average duration of proceedings is admittedly longer. With these three years and 2 months, we do not have to shy away from international comparison. Nonetheless, we strive to get better. In the last few years, we were able to improve the number of concluded proceedings or to keep them on a high level. In some areas, we were even able to shorten durations of proceedings a bit, though not yet to the extent that we would have wished for. Our efforts are often overtaken by the increasing demand for our services. Just to give you an example, in the last 10 to 15 years, search requests increased by nearly 50%. Despite this, we managed to deliver the search reports in 90% of all cases in time, so that customers have enough time left to take a decision on a subsequent application. I have to admit that we are not equally quite as successful with the first official communication containing the first results of our examination. Here, our applicants need a bit more patience due to longer durations of proceedings. But I think I do not have to explain to your expert audience that longer processing times depend on various reasons, which are in no way solely to be found on our side as examination office. To further reduce the length of proceedings, we need targeted measures. To identify them, we have analyzed the needs of our applicants. It has been shown that there are two main interests in patent procedure. About 3/4 of our applicants have a very strong interest in obtaining a patent. They mainly expect us to make fast decisions on their application. Here, we find applicants who want to have their invention protected within Germany, but often also wish for subsequent protection outside Germany. The remaining quarter consists of applicants that are solely interested in a fast and high-quality first assessment of their application by means of a search or a first official examination. We observe that these applicants use our services before they subsequently apply outside Germany. The latter group has little interest in continuing the procedure before my office here in Germany. We are currently considering how we can act in the best interest of both groups. I can certainly say that we will continue to address this topic. And of course, in general, it can be said that if we want to shorten the duration of proceedings, we need motivated and high-skilled patent examiners. Therefore, we are currently recruiting many young colleagues for our office in Munich and in Jena. And we want to make our procedures more efficient by using new technical options, thus taking workload from patent examiners. We want to enable them to concentrate on their core tasks and on a speedy examination.
Thank you very much. I also feel that the German Patent and Trademark Office has become quite popular, especially with the start of the UPC for some strange reason. But some applicants seem to find that this is a very good, clever option to at least also file in Germany now with national patents.
I think you're perfectly right, and I think we will come to this point later.
Yes, that's true.
Mm.
In 2023, you, Ms. Schewior, named AI as an important tool for supporting patent examiners. What has happened regarding AI since then?
Well, of course, we are already successfully using AI at our office. For instance, in the field of patent search, we use a tool using AI, which makes our examiners' work easier. And we also use AI quite successfully for classification and for the translation of Asian patent literature into English. In the meantime, we have seen a rapid development of AI in the market. I think it is strategically imperative to get an overview and to make realistic assessments what AI is capable of doing to make our procedures more efficient. Therefore, we are in the process of observing the market in order to find out how we can make better use of AI. Where can it perform tasks so that we enable examiners to concentrate on their core business? There are many ideas right now in our office where else artificial intelligence can help us tackle challenges. Those challenges are, for instance, the demographic change, which certainly also affects our office. And there are our own quality standards. We will strategically promote new tools in this field to cope with these challenges. But this much is also clear. Humans will always stay in our focus. Especially in public administration, I consider it a fundamental principle that in the end, decisions must be taken and reviewed by humans. AI may help us reach our goals in a more efficient way, but it can never replace patent or trademark examiners.
I agree, Ms. Schewior. You have made quality improvements in patent examination your priority, and you have already implemented a number of measures. How would you describe the current situation?
Well, I often receive positive feedback from different sides that our users are very satisfied with the quality of our examination. I'm very glad about that. But maintaining this quality standard is a permanent task, and we must not become careless here. For years, for instance, we have established double checks for all grants and rejections. And in addition, we have introduced a quality management tool. This quality management tool enables us, even during the examination process, to randomly check the quality of first office communications and searches. This helps us detect critical trends and take appropriate countermeasures at a very early stage. What is also very important when it comes to patent quality is to actively ask the users, our customers, for their feedback. We do this in different ways. Just to give you an example, we have the User Advisory Board. This is a panel of external experts which we have implemented a couple of years ago. And discussing questions on quality is regularly on the agenda of this User Advisory Board. We very carefully listen to their ideas, to criticism and suggestions, and we have already implemented some of their suggestions for the benefit of the office and for the benefit of our users.
My colleague Andreas Gröschel is in this Nutzerbeirat, and he agrees totally. And he's very grateful that you have this Nutzerbeirat, this advisory council. Thank you very much for that.
Very welcome. It's a great board, and discussions are very, very fruitful, and all our user groups are represented. They are also like startups and patent information centers and also patent attorneys. It's a pleasure each time we're meeting.
Yes. The German Patent and Trademark Office, as the largest patent and trademark office in Europe, records nearly 80,000 national trademark applications. What are you currently especially concerned with the trademark area? How have the new types of trademarks under the Trademark Law Modernization Act have been received?
Well, Mr. Claessen, I have new numbers for you. In 2025, we have even seen as many as 95,000 trademark applications. This is an increase of 18% compared to the previous year. I have to say this took us by surprise. Especially applications from outside Germany and above all from China have risen significantly. It is, of course, challenging to cope with such a sudden increase in applications on an organizational level. Another challenge is dealing with so-called trademark applications made in bad faith, which we are currently seeing more and more of. We have thoroughly prepared and trained our trademark examiners on this topic to identify these applications and how to handle them. In terms of the new trademark types you have asked for, the rush has been moderate so far. Sound marks, multimedia marks, or holograms are apparently not yet common solutions for the majority of our applicants. The key focus is still on word marks and combined work figurative marks. Nevertheless, in my view, the new trademarks are a meaningful supplement to already existing types. And I can imagine that as digitization advances, they will play a greater role in the future. The recent legal changes had the greatest effects elsewhere, though. Applicants are now free to choose whether they want to file an application for revocation of a trademark with the courts or with our office. We, too, now fully examine invalidity proceedings due to the non-use of a trademark. The courts may proceed a bit faster than we do, but the financial risk is higher before the courts. By contrast, we apply the principle that each party bears its own costs, so that as a rule, only the moderate filing fees have to be paid. Only in the event of a significant breach of duty of care would we impose the costs on one of the parties involved.
That's great to hear. Thank you. And how does this dynamic filing development impact the periods of procedures in the trademark area?
Mm-hmm. As I mentioned before, this is a major organizational challenge for us, of course. For a long time, our trademark department managed to keep durations of proceedings very short, especially with regard to registration. Despite the increases in applications in the last year, especially in 2025, we hope to avoid a considerable extension of the duration of proceedings. For this, we have recently restructured the organization of the trademark department in order to distribute applications more equally among the various teams. Our colleagues in the trademark department give their very best to process applications as quickly as possible. We know how important this is for our applicants. An important hint for applicants among your audience: it is possible to file a request for accelerated examination. This gives applicants the possibility of a preferred treatment by paying a relatively moderate fee of €200. And there is no question that the filing date determines the seniority of a trademark, and that the length of proceedings does not result in any legal disadvantage in this respect.
This is a very important hint. I tried that myself a lot of times, and I must say that the accelerated proceedings, the accelerated examination sometimes results in registrations within 1 or 2 weeks of filing. So that is really fantastic. So I'm very grateful for this tool.
Yeah, thank you very much. I can only confirm that, and I want simply applicants to know about this option.
Yes, very good.
Thank you.
Now to a very different and very current topic, indications of geographical origin. Since December 2025, so not so long ago, the European Union grants not only protection for agricultural products, but also for craft and industrial products. Has your office already received applications filed for example, Schwarzwälder Kuckucksuhr, cuckoo clocks from the Black Forest region, and Meißner Porzellan?
So indeed, we have the first application, but it is something which you did not mention. I don't know whether your audience knows it. It is garden gnomes von Gräfenroda, garden gnomes. I don't know whether this is known outside Germany. This is indeed a very, very German application. And yes, so we have received the first application. But first of all, protected geographical indications are an important topic. They help maintain traditional know-how in the regions and secure local jobs. I'm glad that it is our office which is named as the point of contact for German manufacturers, and that we can help promote regional cultures and economic power there. We will be the competent authority for geographical indications for craft and industrial products in Germany. The examination proceedings provide for 2 stages: a national phase, in which the DPMA examines the application and submits it to the European Union Intellectual Property Office. In the second phase, the EU IPO continues the proceedings and takes the final decision on the registration in the EU register. What can be protected as geographical indications? They include names of products originating in a specific geographical area, the quality, reputation, or other characteristics of which are attributable to that particular origin. Moreover, at least one of the production steps must take place in that geographical area. The EU estimates that in Germany there are around 40 products that fulfill these requirements. They range from the products you mentioned, but also to Jena Glass and Mittenwald Violence to ties from Krefeld. We look forward to receiving many more applications. In addition, in Germany, the designations Solingen for cutlery and Glashütte for clocks are already protected by national law. This protection will initially continue and expire as of December 2 of this year, of 2026, if no valid application for EU-wide protection has been filed with the EU IPO by that time. We will support both organizations to enable a European registration.
It's good to hear that you are proactively working on this.
Yep.
Thank you very much for that. According to Section 26A of the German Patent Act, the German Patent and Trademark Office has the duty of informing the public about IP rights, and above all, to support SMEs, so small or medium-sized companies. This has led to an increased social media presence of the German Patent and Trademark Office, which I also saw. So what other activities are there in this regard?
So I'm very delighted that you have been following our social media activities. Currently, we are using LinkedIn and YouTube to communicate to our target groups. Our target groups benefit from our content about IP rights that is presented in an understandable way. I think I may say that my colleagues are really doing a great job with this. The content is very informative, and at the same time, it's very entertaining. We also plan to offer special channels on LinkedIn soon, for example, for informing small and medium-sized enterprises. Our aim, our duty is to raise awareness about IP rights for the general public, but especially among SMEs. Studies of the EU IPO show that in Europe, not even 10% of SME use industrial property rights, and that despite the fact that SME which own IP rights earn significantly more compared to companies without such rights. Likewise, in 2026, we plan to further expand our outreach activities through our well-established formats, such as our monthly brown bag seminars. And we aim to expand and intensify the cooperation with relevant partners in the IP ecosystem. Primarily this year in the field of education, and there particularly at technical colleges, at universities and educational academies. The aim is to raise awareness at a very early stage among the entrepreneurs of tomorrow. And in addition, we take part in and we design new studies in this area to better understand the use and the non-use of intellectual property. This is supposed to help us to tailor our services even better. To this end, we will shortly be publishing a highly interesting study on the patenting behavior of innovative German startups. We carried out this study in collaboration with WIPO and the OTH Regensburg, which is a technical university.
I'm looking forward to the study. It will be great.
So do I.
So where do you see the biggest future challenges of patents and utility models and trademarks and designs?
Well, I think I don't have to explain that Germany is a country that depends on innovation. But unfortunately, the fact that these are protected by IP rights or should be protected by IP rights has entered the public awareness only gradually so far. And also small and medium-sized enterprises in particular still seem to be short of information in this respect, as well as startups. We are working on that. In my opinion, another challenge is the fact that companies, especially medium-sized ones, that are aware of IP rights, sometimes completely forgo them and focus on other protection, for instance, on trade secrets instead. They say that getting an IP right is too expensive and takes too long, and that enforcing these rights is even more expensive and complex. Fast-moving industries like IT partly do not work with technical IP rights at all. I think this is regrettable, and in many ways, it's also quite risky. I do not think I have to convince anybody of your audience of the benefits of a patent or another IP right. For reliable protection against imitation, you simply need IP rights. Another phenomenon that worries me is the increase of product and trademark piracy. This is more and more an international phenomenon that goes hand in hand with certain types of criminal activity, especially with organized criminality. Primarily, this of course falls under the responsibility of customs and law enforcement agencies. But we, our office, as well as the patent information centers and other players in the field of IP, still have a lot of awareness raising, a lot of information and a lot of coordination work to do regarding this topic. But I can affirm you, we are on it. And of course, there are challenges for our office. One of them is to remain attractive to our applicants. Applicants today have many different options to get an IP right in Europe. And in general, we need to maintain the competitiveness of the German IP system as a whole. And I'm including the courts here. This entails fast procedures with legally valid results. Another challenge for the office: it is clear that we need to keep pace with technological developments. This applies to qualified staff as well as to their training and further development, as much as to the advancement of our IT. This is a crucial task for us, and also on this task we are taking on.
That's good to hear. Thank you. The German Patent and Trademark Office is looking for staff, as you mentioned. For which areas are you recruiting? What are some good reasons to apply for a job at the German Patent and Trademark Office?
Well, our focus is on patent examination and IT. For patent examination, we started a very successful recruiting campaign in the last quarter of 2025. This led to the hiring of 50 new patent examiners for Munich and Jena. We especially need staff for technological sectors like electrical engineering, e-mobility, IT, and aerospace engineering. Well, there are a lot of good reasons for sending a job application to the German Patent and Trademark Office, but one very good reason is that we are the biggest national patent office in Europe and the 6th largest patent office in the world. This makes us an innovative and multifaceted employer. We really work at the cutting edge of innovation. I think I may say nowhere else in the federal administration can you get as involved in the latest technical developments from all sectors. Next year, we can even look back on 150 years of patent examination. So indeed, we are an established employer with a long tradition. At our office, you will find a meaningful job as well as fair compensation. And that's important, we offer a family-friendly work environment. Besides excellent opportunities for personal development, we provide a crisis-proof job. If you want to apply to us, you will be part of a strong team which places great importance on equal opportunities and inclusion.
I just want to maybe add a little bit. This is not only jobs for university graduates, but for everyone, basically. So, yeah.
This is right. Yeah.
Right.
We need staff at all places. That is completely true. We were talking about patent examination, but also the IT department in our house, in our office, is extremely important. But also like housekeeping, for instance. So we are recruiting in all areas. Lawyers, not to forget the lawyers.
For the trademark department. And the trademark department not only employs university graduates, right? So that's also
You're
important
perfectly
to note.
right.
Yeah,
yes.
right.
Mm.
So is there anything else you want to tell our listeners? Your final message, basically, your most important message, maybe, I don't know, to our listeners?
Yes, thank you for the opportunity. We all know that the introduction of the unitary patent system here in Europe was one of the biggest changes to the patent system in the last 50 years. The many options for choosing appropriate protection in Germany and Europe offer enormous opportunities for applicants. And at the same time, finding a suitable IP strategy is a big challenge for companies. And I think that the German IP rights continue to play an important role here. In my opinion, the European and the German IP systems do not interfere with each other, but they rather complement each other. SMEs in particular often have to consider whether a German patent may already be enough. For many sectors, Germany is the central market in Europe. From the European bundle patent, we observe that protection for Germany is almost always applied for, and then often in few additional countries. So a selective patent strategy may play a big role, especially for SME. And in many cases, SME or startups benefit if they choose the cost-effective and reliable German patent system. But the new framework also offers a big advantage to companies looking for European protection. Unlike in the past, inventions can now be protected by a European and by a national patent. That can be an important strategic advantage, and I think many companies have already discovered this advantage and make use of it. Because if the European patent is challenged and revoked, the national protection will still continue for the time being. So it is important to be aware and well informed on the new provisions and the new options on the European level, as well as the opportunities of the German patent system.
Yeah, I see that as well with my clients, that double patenting is a very interesting option. Some of them actively use that, and it's certainly a very interesting option to have both the unified patent and the German patent in parallel. So thank you very much for opening that route, basically. So thank you very much for being on IP Fridays on our podcast. Yeah, thank you very much.
And thank you for having me and for the opportunity to talk a little bit with you about my office and to present it to you and to your audience. So, and greetings to your audience wherever it may be.
Yeah, the audience is mostly in the US, and the second largest audience is in Germany. So, yeah, so maybe not surprising to you.
So that's very interesting to hear. So let me tell you just a little bit from my personal biography. Before I entered my public service career, I spent 1 year in the United States. At the University of Michigan at Ann Arbor, I obtained a Master of Laws degree there. I tremendously enjoyed this year in the United States, and I remember very well, I heard a class or participated in a class of to American patent law there.
Wow, so that's the reason for your great English. Great to hear that. So, yeah, thank you very much for being on IP Fridays.
Thank you. Bye-bye.
Bye-bye.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.